we got a quorum, right? Welcome and good morning. Today is Wednesday, March 24th. I hereby call the Public Service Subcommittee to order. Madam Secretary, please call the roll.
Representatives Alexander, Jernigan, Johnson, Kiesling, Marsh, Wendell, Chairman Hilton. Chairman Hilton, you have a quorum.
Before we get started, are there any personal orders? Seeing none, we will get started. Today we have 20 bills on the calendar. First up is item number 1, House Bill 1205 by Leader Lamberth. We have a proper motion and second. Do you have an amendment?
Yes, ma'am, Madam Chairman. It's coded 005215.
Is there a motion and second on the amendment? Leader, you're recognized on the amendment.
Thank you, Madam Chairman. And this is a very straightforward bill that I've worked on with the Treasurer's Office. This would take the contribution that the state puts in for the 401k match from $50 to $75 for state employees that choose to go through a very, very limited, what is probably going to be an online training on how to best invest those dollars. So not only would we be increasing the amount of money, but also providing some free information to our state employees on how best to invest those dollars. And the hope is that when they have given a good long service to the state of Tennessee, that they've got a nice, healthy retirement they're waiting for them at the end.
Do we have any questions from the members on the amendment? Seeing none, we are voting on the amendment. All those in favor of the amendment signify by saying aye. Aye. Those opposed? The ayes have it. The amendment is on the bill. Leader, you're recognized on the bill as amended.
Thank you, Madam Chairman. I stand ready for questions.
Any questions from members? Question has been called. All those in favor of sending House Bill 1205 to state full signify by saying aye. Aye. Those opposed? The ayes have it. Bill goes to state full.
Thank you, Madam Chairman. I hope Criminal Justice Sub is half as kind to me as y'all have been. Thank you.
Item number 2 is House Bill 1436 by Chairman Curcio. We have a proper motion and a second.
Thank you, Madam Chairman and committee. There's 2 amendments that I've filed, but if you don't mind indulging me just 1 second, I want to explain what the bill does as filed.
Okay.
And then speak to the amendment, if that would be okay.
That's okay.
Okay, thank you very much. So, House Bill 1436 is in response to a federal Supreme Court decision talking about redistricting challenges. So, as we know, we've got redistricting coming up, and what the Supreme Court has opined is that any, quote, gerrymandering challenges that come up need to be handled by the states. And Tennessee currently does not have a process to do that. Many of you may remember this bill passed on the House floor last year, creating a 3-judge panel to hear those redistricting challenges. That's what the bill does as filed. I did file 2 amendments. The one that I'd wish to move this morning is amendment coded 5638. And I can explain that briefly when you let me know it's appropriate.
Okay. Do we have a motion and a second? We have a proper motion and second. Chairman, you're recognized on the amendment.
Thank you, Madam Chair. So while I was doing my research on this 3-judge panel concept, I came across, and many people are very familiar with how North Carolina deals with challenges to the constitutionality of things. So I discovered that the 3-judge panels have been used elsewhere to hear what are called facial challenges on the validity of state law. And facial challenges seek to discredit the legislature's action as unconstitutional across the board rather than unconstitutional as it may be applied to a specific person. It seemed appropriate to me to include these facial challenges under the jurisdiction of this 3-judge panel were we to create one in Tennessee, because these important legal questions with statewide implications really should be heard by a panel of judges across the state rather than just one particular chancellor from one particular city or one particular area. So the idea there would take these facial challenges to a statewide panel, again, modeled on what North Carolina does. With that, I'd be happy to answer any questions.
Questions from members? Chairman Kiesling, you're recognized.
Thank you, Chair Lady. And Chairman, have there been any challenges coming out of North Carolina with their makeup, if you will, of how this is working over there? And that's not the proper term. But anyway, you know where I'm going with
Sure.
it. Any challenges that's coming out of there?
Chairman.
Thank you, ma'am. It's my understanding that North Carolina has a pretty good process. I have been working with our AOs, the Administrative Office of the Courts here in Tennessee. I know they're here this morning. We definitely, a lot of this language that I've got is borrowed from the North Carolina statute, but our system doesn't work exactly the same way theirs does. So we're definitely working together, and I would anticipate that we're going to fine-tune this thing before we, come back to you guys in full. But we wanted to go ahead and get the structure built so that way we can kind of tinker around the edges.
Chairman Keesling?
Thank you, Chair Lady. Chairman, now the facial challenges, could you explain that a little, go in depth, just a little bit? Let's don't go into the weeds now on me, but you know what I'm saying. Can you?
Sure. So a facial challenge means that something that the legislature did was just outright unconstitutional across the board, as opposed to unconstitutional as it's applied in one particular case or one particular person. So it's somebody just saying outright, we challenge the constitutionality of this whole cloth.
Okay.
And so since it's that approach as opposed to a specific incident, we feel like sending those challenges to just a chancellor in a random part of the state doesn't make near as much sense as having like more of a statewide panel approach to this, because it would have statewide implication if the constitutionality was challenged on its face.
Chairman Keesling?
Thank you. Excuse me, for my final question, Chairman. So we're talking about then one from each grand division. Then is that the way? Just to clarify for the record.
That's
for me.
Yeah. So okay. The bill would have the Supreme Court impanel a 3-judge panel.
I got you. Okay. Thank you, Chairman. Thank you, Chair Lady.
Chairman Jernigan, you're recognized.
Thank you, and thank you, Chairman Curcio. And I have two questions, and we had spoken about earlier, but I thought the optics were not the greatest in the world. But is it the Chief Justice will be appointing? Is that right? The 3 judges across the appellate judges to the court?
I'm sorry.
You're recognized.
Thank you, ma'am. So just reading from the amendment, when action described in subdivision A1 or a challenge described and so forth is filed, a person or entity filing the action shall provide notice of complaint to the presiding judge of the judicial district, which shall serve as the presiding judge of the 3-judge panel required by subsection A. Upon receipt of notice of the complaint, the presiding judge shall notify the Supreme Court, who shall, by a majority vote of the court, appoint 2 additional trial court judges. So this would change the venue. It would take it to where the person is challenging. That presiding judge would notify the Supreme Court. The Supreme Court would vote to appoint 2 additional judges, which is how you get to the 3-judge panel.
Okay, I understand. And there's no fiscal note on this. So when the appellate judges leave their division, one of my concerns is that I'm not sure what the docket is going to look like. And if there's a large docket, then I'm taking these judges out of their roles and bringing them to this tribunal. Will they have staff and clerks with them as well? Or are they just on their own? Or how does that work? Is it when there's no note, then I imagine there's no staff, or it increases
Chairman, you're
expenditures by
recognized.
20,000.
Thank you, ma'am. The bill doesn't speak to that specifically. I'm sorry, did you have?
Oh, I see now it does say that it exceeds $20,000. Okay. So the appearance is what I'm concerned about, and I had to write this down because I couldn't remember it on my own. But Rule 1.2 of the Tennessee Judicial Code of Ethics is, quote, promoting confidence in the judiciary. And what it says, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Now, when these judges appoint a tribunal, knowing that whoever they appoint is going to come back to them in an appeal, and the circumstance at that point calls into question, I think, the independence and the integrity and the impartiality of the judges that appoint people that are going to come back to them. To me, it challenges the independent judiciary of being separate, and they're just cross-referencing each other, appointing people that know they're going to come right back to them, if that makes sense.
Chairman Curcio?
Thank you, ma'am. When you say folks that are going to come right back to them, I mean, this is where these challenges would stay. Or you just mean in other cases?
On an appeal. When it goes to an appeal, it goes back to the judges who appointed them. Right, because on an appeal, it goes to the Supreme Court?
Well, that's right, but I mean, judges have that, I mean, they have that problem now. I mean, they all know each other.
Well, but they don't appoint them to special tribunals to where they rule, and then the appeal comes back to them. It's like they'd have to accuse themselves for people they appointed to rule something. Now I've got to, anyway, I think it's a concern with the way it's written, but I think there's a lot of unknowns on this. I'm probably going to have to be a no on your vote, but thank you for listening to me and
Sure,
answering my
absolutely.
questions.
Chairman Curcio, any more comments?
Again, I would just say, speaking really to the motive of the bill, as we started our research and looking at, there are more and more challenges to constitutionality of statutes, and I think we've seen what the perceived unfairness when we've arbitrarily picked, a specific chancellor in a specific part of the state to hear these challenges, just because they're in the middle of the state or they're, someplace else. So for facial challenges, which again would have statewide ramifications, we just felt it more appropriate to have a statewide board of judges that look at these things.
Chairman Kiesling.
Thank you, Chair Lady. Where are we posture-wise? Are we on the amendment? We are on the amendment. We've got a motion and a second here on the amendment. Okay. Thank you.
Yes. Any further questions? The question has been called. We are voting on the amendment. All those in favor of the amendment signify by saying aye. Aye. Those opposed? The ayes have it. The amendment is on the bill.
Thank you,
Chairman,
Chair Lady.
you are recognized on the bill as amended.
Thank you so much. I would renew my motion. I'll just say that, again, now as amended, not only have we taken care of the Supreme Court, this federal Supreme Court ruling that states should handle any sort of redistricting challenges, but now also, as the bill as amended, would handle those facial constitutional challenges as well.
Speaker Marsh, you're recognized.
Thank you, Madam Chairman. And according to this, these judges that are appointed should already have a staff. I would think they've got people in their office already.
That's correct.
And it wouldn't change a whole lot. So that's why there's no note on it, I'm sure. Okay, thank you.
Chairman Jernigan.
I guess I'm looking at there is a $20,000 note, but if they're going to bring their staff with them, then the appellate courts where they're usually at are going to have a docket that's going to be backed up now for people to be waiting because they've been moved to another venue. But I just wanted to say that there is a $20,000 note on this.
Questions? I will call a question. Okay, the question has been called. Any objection? Seeing none. All those in favor of sending House Bill 1436 to state full signify by saying aye. Aye. Those opposed? No. The ayes have it. Bill goes to state full.
Thank you, Madam Chair, and thank you, committee.
Item number 3 is House Bill 853 by Chairman Carr. We have a motion and a second. Do you have an amendment?
Yes, Madam Chair Lady, I do. I have amendment, Drafting Code 4520.
There's a motion and a second on the amendment. Chairman, you're recognized on the amendment.
Thank you. Basically, what this amendment does, each year, every 10 years, we have a redistricting, and we're supposed to have that done by January the 1st of 2022, of course. But because the census is not coming down from the federal government because of COVID and everything, this amendment just allows the comptroller of the Treasury, on his discretion, to based on the United States Census Bureau, delay in releasing the results of the 2020 federal census. And that's just giving him the authority to do that because we don't know when they're going to be coming down. And we gotta put something in place before we're out of date on this to do the redistricting.
Do we have any questions on the amendment? Question has been called. We are voting on the amendment. All those in favor signify by saying aye. Aye. Opposed? Ayes have it. Amendment is on the bill. Chairman, you're recognized on the bill.
I would just renew my motion, Madam Chair Lady.
The question has been called. All those in favor of sending House Bill 853 to state full signify by saying aye. Aye. Those opposed? Ayes have it. Bill goes to state full.
Thank you, Chair Lady and committee.
Item number 4, House Bill 954 by Chairman Littleton is rolled 1 week. Item number 5, House Bill 432 by Representative Lynn has been rolled 1 week. Item number 6 is House Bill 869 by Chairman Zachary. We have a motion and a second. Do you have an amendment?
Thank you, Madam Chair. Yes, ma'am, I do. Thank you, Chairman. It's drafting code 4316.
Chairman, you're recognized on the amendment.
Thank you, Madam Chair. Members, I would ask for your indulgence. Typically, we don't like lengthy presentations, but there is no way for a topic like this for me to be brief because I want to make sure I provide context and detail. So I would just ask for your patience as I provide you with a somewhat lengthy presentation. Members, the piece of legislation we're going to discuss today is the result of the ad hoc committee work over the summer. Our ad hoc was organized as an ad hoc committee to study the current authority granted to the executive branch of government with regard to declaring a state of emergency and the powers granted to the executive branch during a state of emergency. So I want to first thank Speaker Sexton and McNally for just recognizing and listening to not only us as the General Assembly, but the people of the state and establishing this ad hoc committee to review executive powers during a state of emergency. And let me also say before I get into the presentation that as we walked through this and as we met through the summer and the fall, and Speaker Johnson was a part of that ad hoc committee, it became very apparent and very clear that we are blessed to have Governor Lee leading our state during this time. As we kind of walk through this, you will realize how measured and steady our governor has been and the enormous power TCA 582107 grants to our executive branch. It will become apparent and very clear as we found out as an ad hoc committee how measured and steady he has been, because the way the current statute is drafted, the only limitation on our executive branch, on our governor, is that he cannot touch our guns during a state of emergency. And for some, that may create a chuckle. That's kind of what was our response as a committee. But the only limitation on a governor during a state of emergency through TCA 582107 is that he cannot touch our weapons. A state of emergency and the executive order cannot be extended for longer than 60 days, but it can be renewed at the governor's discretion. So it's important to remember we were one of the last states to have any kind of close down. We were one of the first states to open back up April 27th. We have had very few statewide mandates. Many of the restrictions we face, the restrictions we currently face in Knox County, are a result of the health board, which is a whole other issue that the House has already dealt with. But again, it is important to remember that our governor could have taken tremendous and enormous steps in a very tyrannical fashion in our state, but he did not do that. This work of this committee is to ensure that whomever the next executive is, either 8 years from now, 10 years from now, 20 years from now, that the individual liberty and constitutional protections we're provided are in TCA 58, and that we put some parameters around the executive powers. We are one of only 12 states that has no legislative engagement currently today within executive powers at the time of our ad hoc committee. So it's extremely important to understand that to put that into context, that is what we're discussing today. This has zero reflection on our current governor, because he has done a fantastic job in leading us through an absolutely unprecedented time. But it is important that we protect the future of our state from a governor who may want to make different decisions and would have the absolute ultimate authority to be able to do that. So let me walk briefly through the recommendations of our ad hoc committee. Let me just give you a quick makeup of that committee. It was Deputy Speaker Johnson, Chairman Boyd, Chairman Hazelwood, Chairman Howe, Vice Chairman Hurt, Chairman Moody, Chairman Reagan, Representative Clemens, Freeman, Lamar, and Shaw. And what you were getting ready to hear today, the recommendations on our recommendations as an ad hoc committee for TCA 582107 had the unanimous support of the House members of that ad hoc committee. So let me walk you through this quickly as I can, and I will be glad to answer any questions. Again, that amendment was drafting code 4316. First and foremost, we are going to, this piece of legislation creates a new section within TCA 582107. Everything you're going to hear about today will be under the section of a health crisis or a health pandemic, a public health emergency. We went back and looked, and for the last 30 years, any state of emergency related to a natural disaster or security threat, the longest state of emergency we could find was 30 days, and that was under Governor Bredesen during the Nashville floods. Typically, state of emergencies on a state level are extremely short. But during this pandemic, we have now set a precedent that has to be addressed because we're now 12 months into a state of emergency. While we have very few executive orders and very few restrictions, except in our metro area, we have still set a precedent that a state of emergency can be extended forever and ever, amen. And that's part of what we're addressing here. So everything that I'm going to mention will be a new section within TCA 582107 that only applies during a health emergency or health crisis. Natural disaster, security threats, those are untouched. Governor needs flexibility, needs to be able to maneuver through those quickly. Those remain untouched. This simply has to do with a public health emergency or health crisis. So first, when a state of emergency is declared, a legislative council will immediately be created. That legislative council will exist of 4 ex officio members. There's a legislative council for each chamber. So you will have the speaker of each chamber, the majority leader, the minority leader, and the majority caucus chairman. Each speaker will then appoint 3 additional members, 1 from each grand division. So that will give you a total of 7 members on the legislative council. The first recommendation from our committee is that, and this is one of the most basic that most states have, a state of emergency can be terminated at any time through a joint resolution by the body, period. Recommendation 1. Recommendation 2 within this legislation is that at the 30-day mark of a state of emergency, and we are not in session, the body is not in session, the legislative council at the 30-day mark has the ability to begin a 5-day review with the executive branch, and at the end of that 5-day review, they can choose to basically put a stay on that state of emergency until the entire body can come in for additional action. That is if we are not in session. That gives us an option. That is only an option. It is not a requirement in this legislation. At the 30-day mark, we have the option to be able to step in. Number 3, this legislation says that a state of emergency cannot extend beyond 60 days, period. If we are not in session, the legislative council can provide for a 15-day extension until the entire body can come in to address the state of emergency. So a state of emergency cannot extend beyond 60 days. If we are not in session, the legislative council can extend that stay after working with the executive branch until the entire body can come in. Third is reporting. This legislation requires the executive branch to give our body a 24-hour notice after the initial executive order is issued. For each additional executive order, we're provided a 24-hour notice with the fiscal note, the details of the guidance, and any future guidance that will be provided. And then lastly, this requires the Department of Health to bi-weekly come before the Government Ops Committee to provide reporting to the Government Ops Committee with the same kind of detail. Fiscal note, why the guidance is being established, and what that follow-up guidance may be. So those are the recommendations that our committee came up with after, I think we met 3 times, and we had expert testimony from everyone from Chief Justice Koch, former Chief Justice Koch, General Gonzalez, who was Attorney General under President Bush, Glenn Reynolds from University of Tennessee, our current General Slatery, had expert testimony and extensive meetings, and this was the result of those meetings. And so, Madam Chair, that was as brief as I could be while providing the entire context, and I will be glad to answer any questions.
Okay, members from do you have questions? Okay, Chairman Jernigan, you're recognized.
Thank you, Chairman. The first one you said that that the body can terminate, would that be a 2/3 vote or just a majority?
You're recognized.
Thank you, Madam Chair. It's through a joint resolution, and so it would just be it's a majority. Yeah.
Okay.
But that would require the entire body, and that would require us to be in session to do that.
And that leads to my second question, Madam Chair?
You're recognized.
So would the body have to have 2/3 to call session on its own? To call a special session, does that legislation automatically call a special session, or do we have to have our 2/3 signatures?
You're recognized.
Thank you, Madam Chair. The legislation is clear so that particular piece of what you're talking about, where we can terminate a state of emergency at any time, that is, the legislation assumes we're in session. So that's just that. Most states have that. We're one of 12 states that has no legislative engagement at all during a state of emergency. So that in its basic form means we have to be here to be able to do that. But then kind of what you're talking about at the 30-day mark, at the 60-day mark, that does trigger and make specific that the governor would have to call us back in.
The governor required to do
Correct,
it.
for a special session, yeah. And this does not change the requirements in statute, the requirements for a special session to be called in terms of the governor calling or the number of members that have to sign on. All of that stays as is.
Okay, that's all. Thank you.
Any further questions on the amendment? Seeing none, we are voting on the amendment. All those in favor of the amendment signify by saying aye. Aye. Those opposed, the ayes have it. The amendment is on the bill. Chairman, you are recognized on the bill as amended.
Thank you, Madam Chair. Members, the explanation of the amendment is the explanation of the bill, so I'll be glad to answer any additional questions.
Chairman Kiesling, you're recognized.
Thank you, Chair Later. No questions. I think I can speak on behalf of all of us sitting around in this committee today to thank you, and all those that took the time to work. This was very difficult, and I'm sure time consuming. And Chairman, thank you so much for all that you've done.
Thank you, Chairman.
Appreciate it. Thank you, Chair Lady.
We do have someone here to testify, and so without objection, we will go out of session and hear from Valerie Yancy.
Thank you,
You're
Madam Chair. If I could be recognized
Yes.
quickly. Before we vote, I would like to make a closing statement, if I may.
Absolutely.
Thank you.
Okay. We are now out of session. You're recognized, Ms. Yancey. Oh, okay. Thank you for joining us today. We have a 3-minute limit for testimony. Please introduce yourself and tell us who you represent for the record.
Good morning, Chair Lady and members of the committee. I'm Valerie Yancy, Governor Lee's Deputy Director of Legislation. Our arguments for this are very similar to what I expressed to you all yesterday on House Bill 1347. While we continue to hear that Governor Lee has done a great job, and I certainly believe that, there seems to be a question because these bills are all going into effect now, not in the future. So we feel like this is being thrown at us in the middle of what we are still in, a global pandemic. And we feel like this is not the time to go down a path until we can get this fully under control, as much as any pandemic can be put under control. Yes, there were a lot of people that spoke at the committee this summer, and there is a portion of this bill that is unique that calls for the 14-member legislative council And the experts that testified on that felt like that would be an unconstitutional thing. While you could say that that would be, the group would make a suggestion that would go to the full legislature, if we are in a situation where the legislature cannot call themselves into session because numbers are affected, then what? Where does that leave the state, and where does that leave our citizens? And while this does not specifically, this talks about a health crisis rather than a natural disaster, such as an earthquake on the New Madrid Fault that could absolutely cripple West Tennessee, that would become a natural health disaster under any of the situations that would happen with the infrastructure. So while it might not be this legislature, a legislature in the future that might feel a little more zealous on how they do things could say that they could call anybody in to question the governor's actions when you couldn't possibly get here. So there are concerns on that portion as well. And as we expressed yesterday, we just don't feel like starting this right now as soon as the bill becomes a law is very helpful while we are still trying to deal with a global pandemic on the state level. So the governor is flagging on this bill. Thank you.
Any questions from the members? Okay, there's no questions. We are back in session. Chairman, do you have any further
I
discussion?
do, Madam Chair, thank you. Members, there is an amendment that you will see in the full committee. This is going to be part of my closing statement. It was simply my error. I did not instruct legal in the enacting clause to ensure that the enacting clause says when the current state of emergency ends, this piece of legislation is enacted. And so when I discussed this with the governor, I told him that, again, this was a no reflection of him. And so this piece of legislation, I can't speak to any other legislation, but I have an amendment drafted that I did not file because it would not have been timely filed, that simply says the enacting clause is the only change, and it simply says that this will not go into effect until the current state of emergency ends. So to address that point. There was the testimony regarding the Legislative Council, and there were some constitutionality questions regarding the Legislative Council being able to stop or completely eliminate a state of emergency, and that's why the legislation was drafted in a way that says they can only put a stay on it, similar to what government ops does. They can only put a stay on a state of emergency until the entire body can be called back in. And then and again, the 30-day mark that I mentioned is simply optional. At the 60-day mark, the Legislative Council has the ability to issue extensions working with the executive branch. So even if the full body, God forbid, something terrible happened, even if the full body could not be here, that Legislative Council is able to provide an extension. So, Madam Chair, let me be really, really, really transparent in my closing statements. The governor was my friend before he became governor. My relationship with Bill Lee predates his time serving as governor. I love him as a person, I love him as a brother in Christ, and I trust his leadership. And there is a reason that I was made chairman of this committee, and part of it was because of my relationship with Governor Lee, because I think that the Speaker knew I would be fair, but yet seek what needed to be done to address the future of this state. As I explained in TCA 58, the way it is drafted now, under the way it's drafted right now, a governor could do anything he wants to do. It specifically says he can suspend any law or regulation and can renew a state of emergency every 60 days at his discretion. There is no limitation. Every person that testified in our committee said there was no limitation on what he could do. So as Tennesseans hear and listen to this testimony, they have to understand that if we had somebody other than Governor Lee leading our state, it would have looked very different. We could have looked like Kentucky. We could have looked like Ohio. God forbid we could have looked like California. But yet our state is one of the 7 states that grew economically during this pandemic, because we cannot just look at the health ramifications of a pandemic. Lives in society are on the line or at risk, and the governor took all those into account. Many of us were involved in some of those first calls where we heard 250,000 Tennesseans were going to die. Hospitals were going to be shut down. That is an impossible situation in which to lead. A couple of weeks later, and I believe it was sometime in April, many of us were on a call with an institution where there was literally disagreement on the call within the institution about what the numbers were going to look like. There is no way for anybody to lead through an impossible situation like that. The numbers continued to change. The target continued to change. And when you take all that into account and the weight of making a decision that affects the livelihood and well-being and health of 6.8 million people, and then you take a step back and look at how the governor has led, he should be commended for how he has led. Do we agree with every decision he's made? No, absolutely not. And I'm not saying that. But you take his work as a whole, and I would put it up against anybody, any governor, and how they handled this pandemic. So it was important for me, because of my relationship with the governor, I wanted to make that very, very clear. This piece of legislation is in no way a reflection on him, but this legislation is a reflection on how we have to protect our state and the constitutional liberties of the people of our state moving forward. This has to be passed and this has to be enacted because the precedent has been set. And again, the next person, whomever leads this state, may not be as measured and steady and may be moved by the whims and the flows of the experts of whatever industry it may be. And so with that, Madam Chair, I will rest and take any questions.
Any questions from the members? Seeing none, we are ready to vote on House Bill 869. All those in favor signify by saying aye. Aye. Opposed? The ayes have it. Bill goes to state full.
Thank you, Madam Chair and committee.
Item number 7 is House Bill 573 by Chairman Reagan. We have a motion and a second. Chairman, you're recognized on the bill.
Thank you, Madam Chair Lady and Committee. I bring you a bill brought to me by the Comptroller. It is designed to save our state money, and in recognition of the fact that we are in the digital age, no longer Ben Franklin's printing press age. Essentially what this bill does is change the requirement for notices to be published for hearings where state agencies or government entities are being restructured, continued, or terminated, which, by the way, is the function of the Government Operations Committee, which I chair. The Comptroller is required to put this notice out for every time we do that, and I can personally tell you that you've seen those sunset bills come forward. I now have more bills passed than anybody in this room. That's how much notice has to be put out. It would save our state $68,000 a year or more to be able to do this online. And that's what this bill does. It simply says that we will no longer spend $5,664 a week putting these things out in newspapers across the state. Instead, we will publish it on our website. With that explanation, I stand ready to answer questions.
Any questions from the members? The question has been called. All those in favor of sending House Bill 573 to state full signify by saying aye. Aye. Opposed? Ayes have it. Bill goes to state full.
Thank you, Madam Chair and Committee.
Item number 8, House Bill 509 by Chairman Boyd has been rolled 1 week. Item number 9, House Bill 1540 by Chairman Weaver. We have a proper motion and a second. Do you have an amendment on the bill?
No, I do not have an amendment. Don't believe it. Oh, yes, I do. Excuse me.
What is the
Forgive
drafting
me.
code?
It is drafting code 4372, and it simply includes utility districts.
Okay, do we have a motion and second on the amendment? Motion. Chairman, you're recognized on the amendment.
Did I say 4362? I meant to say 4372. Oh, okay. Sorry. Okay, so the bill simply was brought to me, and the intent of the legislation is that government employees often desire to change their employment, move, or would consider a change in employment from one government entity to another government entity. So in many cases, the employees have invested funds into a retirement system. In almost all cases, the local county or state government has allocated or invested money in a pension system on behalf of the employee. This legislation will create a mechanism to allow the affected government entities to transfer the funds invested in a pension system to the employee when the employee changes government employment. This legislation will also address the situation where some employees work side by side, but some of those employees are employed by state government and other employees are paid by the county government. One example is an assistant district attorney in a county. Also, this legislation is enabling legislation. It does not require participation by any government employer, so it is permissible. Employees transferring between state government and local county government entities would like the option to continue in a pension plan. This legislation will only affect government entities in the state of Tennessee. There are other jurisdictions that serve as a model for this piece of legislation, which include North Carolina, Georgia, Minnesota, and Colorado. That explains what the intent and the spirit of this bill does. I'll take any questions.
Okay. Chairman Jernigan, you're
Thank you.
recognized.
I like the bill. Does it, if you work for a local government or a county government and then they get a state job, would it also transfer over? Would the pension transfer to the state as well, or is just local and county?
Yes, as I understand, it does. It's kind of like, the way I thought of it is like the money follows a child in education, the money follows the employee in this legislation.
So it includes the state as well? Right.
Yes, sir.
Okay, thank you.
Any further questions on the amendment? Okay, we are now voting on the amendment. All those in favor of the amendment signify by saying aye. Aye. Opposed? The ayes have it. The amendment is on the bill. Chairman, you're recognized on the bill as amended. The question has been called. Any objection? Seeing none, all those in favor of sending House Bill 1540 to state signify by saying aye. Opposed? Ayes have it. Bill goes to state full.
Thank you, Chairman. Thank you, members.
Item number 10 is House Bill 700 by Chairman Halsey. We have a proper motion and second. Chairman, you're recognized on the bill.
Thank you, Madam Chair Lady, and thank you, committee. It's early in the morning. My bill is pretty simple. House Bill 700 says that executive branch or mayor, local branch, executive branch cannot use police power to enforce an executive order that deals with three constitutional issues: the right to assemble and worship, the right to go to work and earn a living, and the right to move around this state unencumbered by government. And I want to express and piggyback off of what Chairman Zachary said. I have full confidence in our governor. I don't know who the next governor will be. I'm not worried about our governor. He is a just man, and he has done well. I do worry about mayors, and I worry about health directors and health boards. And there's an issue here where if you use police power to enforce an executive order, that's a form of fascism that our Constitution doesn't recognize. You see, we have three branches of government in this state. The Constitution dictates it. And the legislative branch does not have, I don't believe, the constitutional authority to cede or endow the executive branch with the power to make law, nor the judicial branch. So when you use law enforcement to enforce an edict or a fiat out of a mayor's office, besides the fascism issue, it's illegitimate law. The mayor doesn't have the authority constitutionally to make law. So the legislature can't endow the governor with it, and the governor can't endow a mayor with it. And therefore, we shouldn't put police in this state in that kind of position. They took the same oath you did. And we should not hem them up and force them to enforce not law. That's your and my job, to make law. That's what police enforce, but to enforce executive orders. So that's the long and short of it.
Okay. We have Chairman Jernigan, you're recognized.
Thank you. Why am I the only one talking here? It's, quick, but we do have 3 branches of government, so technically though someone could go to court and the court could enforce, that would be how an executive order would be enforced. If an individual or a mayor wanted to go to court and challenge it, then the enforcement could come from a court, right?
Chairman Holson.
I'm not sure. I would think the court would have to act on legitimate law passed by a seated legislature. I don't know.
Okay. All right. I was just thinking that would be the only enforcement that someone would have, be the court system. And since they are a 3rd branch, that would be. Yeah. All right.
And
Well, they could rule something unconstitutional, I guess.
Chairman,
All right.
you're recognized.
And also, this only deals with 3 constitutional issues. This doesn't prevent a mayor or a governor from dealing with anything else that they have to deal with and use police to do it. It's only these 3 constitutional issues.
Any further questions? Seeing none, we are voting on House Bill 700. All those in favor signify by saying aye. Aye. Opposed? The ayes have it. Bill goes to state full. Thank you for meeting, Chairman. Item number 11 is House Bill 1050 by Chairman Lafferty. It's rolled 1 week. Item number 12 is House Bill 1322 by Representative Hardaway. I do not, he stepped out. Okay, we're going to roll that to the Hill. Item number 13 is House Bill 1492 by Representative Towns. Do I have a motion and a second? Motion. Second. Representative, you are recognized on the bill.
Thank you, Madam Chair. Committee, Safety and I are working on an amendment for this. So if you don't mind, I'd love to roll this until next week.
Okay, without objection, we will roll this times 1 week.
Yes, ma'am.
Item number 14 is House Bill 1488 by Representative Towns. We have a proper motion and second. Representative, you're recognized on the bill.
Thank you again, Madam Chair. Members, this is self-explanatory. It's just simply the equipment that you all use, we use, you know, it's often it's decommissioned. This is probably new stuff that you have right now, okay? I think they get rid of it maybe every year or 2. And so what happens is that it will allow us as members an opportunity to, at the market value, purchase that equipment that you've been using all along. And essentially, that's what it is. It doesn't encourage anything to happen, accelerate it. Just whenever the state decides to decommission, you have an option to do it if you'd like to. And that's essentially what it boils down to. Madam Chair, with that explanation, I'll take any questions.
Speaker Marsh, you're recognized.
And I happen to agree with you.
Thank you.
And I know now we cannot buy our equipment. Have you talked to the legislative staff? Are they in agreement with what you're trying to do?
I didn't do it this year, but last year I did.
And they were okay with it?
Yes, sir.
All right, thank you very much.
My pleasure.
Any other questions? The question has been called. All those in favor of sending House Bill 1488 to state full signify by saying aye. Aye. Opposed? Aye has it. Bill goes to state full.
Madam Chair, may I, on the way out, I just want to thank you for how well you treat me. None of these jokers up here treat me as good as you do. I just want to let you know, okay?
Thank you. House Bill 15. I'm sorry. Item number 15 by Chairman Sparks. Do not see him. We'll roll that. Oh, there you are. Okay, I'm sorry. Members, there is an amendment traveling with the bill from pensions and insurance. Okay, we have a motion and a second. Chairman, you're recognized on the bill.
Thank you, ma'am. Basically, this bill just helps our locals to have the bridge program for correctional officers and also adds EMTs. As many of y'all know, we're losing a lot of correctional officers. It's hard to retain these guys and ladies as well. The state's had a tough time with it. The locals have had a tough time, not as tough as the state. But this would allow them to retire 25 years of credible service, and I think it's a move in the right direction. I also have someone here, Michael Agee with the Tennessee Sheriff's Association, who'd be willing to speak if y'all needed him.
Does anybody want to hear the speaker? If so, Chairman, you're recognized.
Did we get a motion and a second on this amendment? We did? Oh, okay, yeah. So-
It's traveling with the
It
bill.
did not, I'm sorry. Okay. Madam Chair, I would like to hear
Okay.
testimony, if you don't mind.
Yes, we will now go out of session for some testimony. Thank you for joining us today. You have 3 minutes, and will you please state your name and who you're with for the record?
Thank you. I'm Mike Agee. I represent the Tennessee Sheriff Association, and I will not take 3 minutes. This is a bill, law enforcement officers were given this 25-year option, and then correctional officers were added, EMTs were added, and inadvertently our local correctional officers were left out. That's what the first part of this bill does, is to give our jailers that 25-year option. The second part is the bridge program, that if you have mandatory retirement ages, it's that program that I am not real well versed in, but it is completely optional. It is permissive for the counties. If they want to offer this to their employees, they have that option. And this would also allow them to offer that option to that same group of people, being the correctional officers. And that's what the bill does. We are bringing it on behalf of the Sheriff's Association. The one that really brought us to us is your sheriff, Sheriff Fuson, up in Montgomery County. But this is a tool that they can use to small help to recruit people, because you can imagine how hard it is right now for us to staff our local jails. So that is what the bill does, and we appreciate your support, and I will answer any questions you have if I know the answer.
Any questions from the members? I don't think we have any. Thank you.
Thank you
for speaking. We will now go back into session. Chairman, do you have any further discussion on the bill?
No, ma'am, I just appreciate this committee and appreciate y'all's heart and passion for our correctional officers.
Any further questions? The question has been called. All those in favor of sending House Bill 171 to state full signify by saying aye. Aye. Ayes have it. Bill
Thank you.
goes to state full.
Thank you, Chair Lady. Thank you, members.
Item number 16 is House Bill 1401 by Representative Cochran. We have a proper motion and second. Representative, you're recognized on the bill.
Thank you, Madam Chairman. HB 1401 is really just a very small cleanup in language regarding reimbursement for members. We've, in the past and currently, we've had members maybe who are pilots and will fly to session. There's really no way currently for them to be reimbursed for travel. This restricts, sets the limit at reimbursement for road mileage, so they can't be reimbursed for any more than what we would be reimbursed. But currently, because again of a little nuance in the law, they are not eligible for any reimbursement. But with that, I'll pause for questions.
Any questions from the members? Question has been called. Any objection? Seeing none, all those in favor of sending House Bill 1401 to state full signify by saying aye. Aye. Opposed? Ayes have it. Bill goes to state full.
Thank you, Chairman and Committee.
Item number 17 is House Bill 456 by Representative Thompson. Do I have a motion and a second? Representative, you're recognized on the bill.
Thank you, Madam Chair. This is a bill regarding 457B plans. These are employer-sponsored, tax-favored retirement savings account. It's also known as a deferred compensation plan. And they act like 401k plans, only they're only offered to public sector employees and a few not-for-profits. Now, state law allows the state and local governments to auto-enroll their employees in a 457B plan if their employer uses the state-sponsored plan. But when a local government uses a private 457B plan, current law does not allow the local government to auto-enroll their employees. In several large counties in use private plans. If enacted, all local governments employing 1,000 or more employees would have the option to auto-enroll their new employees in the 457B plans. And of course, employees can always opt out. They're not forced to take this plan, and if they get into the plan, they can get out at any point too. It's a common practice to auto-enroll employees in both the public and private sectors, and the Tennessee County Services Association is supportive of this legislation, and it was came out with a favorable recommendation from Pensions and Insurance. Happy to answer any questions.
Do we have any questions from the members? The question has been called. Without objection, we are now voting on House Bill 456. All those in favor signify by saying aye. Aye. Opposed? Ayes have it. Bill goes to state full.
Thank you, Madam Chairman and members.
Item number 18 is House Bill 658 by Representative Haston. We have a motion and a second. Representative, you are recognized on the bill.
Thank you, Madam Chair. This bill was brought to me by the Comptroller's Office, and it will probably be the most exciting bill that y'all hear about today. I look forward to bringing it to you. This bill refines the code regarding the Comptroller's review of procurements. It reduces the number of low-risk contracts that the Comptroller's Office reviews by establishing a minimum threshold of $5 million for cooperative purchasing agreements. And with that, I'll be glad to answer any questions.
Okay. We do have someone here to testify. Do we? Just in case. Okay. Well, does anybody have any questions or comments?
I've got a comment. We've had a lot of comptroller bills today, so, and, well, the comptroller's got a lot of bills. But, so they were pretty exciting too. And so.
If you would like for me to roll this a week so we can discuss.
Chairman, no.
I'll be glad to entertain.
Don't bring this back to me.
Okay.
The question has been called. Without objection, we are now voting on House Bill 658. All those in favor signify by saying aye. Aye. Those opposed? Ayes have it. Bill goes to state full.
Thank you, Madam Chair.
Item number 19 is House Bill 969 by Representative Dixie. I do not see him here. We will roll that to the Hill. Item number 20 is House Bill 1296 by Representative Johnson. She is not here. Are we out of time? We are back on item 12. Representative Hardaway is not here either. Okay. We are back to item number 19, House Bill 969 by Representative Dixie. Do I have a motion and a second? We have a proper motion and a second. Representative, you are recognized on the bill.
I had to catch my breath getting here. Other committees aren't as efficient as this committee. So thank you. I appreciate you in this. So this bill is, well, it will create a database for some of the bad actors. We all want to make sure that we get the best of our law enforcement in the best position that they can. And we want to make sure that the bad actors don't move from county to county, jurisdiction to jurisdiction, if they have committed a gross infraction. And that's what this bill intends to do. And I think that we've seen all over this country that one bad apple makes it bad for everybody. And we understand that all police officers aren't bad, but there are a few bad actors. And I believe this is an important bill, and we still have some work to do on it. And I'm working with some other agencies because I need to get all stakeholders on one page. And I think that we can come to an agreement on what we need to do. But I just kind of want to explain to you what the bill does, but I would like to take it off notice.
Okay. Without any objection, the House Bill 969 is off notice. Thank you. We'll roll to the next. Okay. All right. Okay, let me get to it. My papers are out of order. Okay, here it is. Okay. Item number 20, House Bill 1296 by Representative Johnson is going to be rolled times 1 week. Yes. And item number 12, House Bill 1322 by Representative Hardaway. We're going to roll to the next calendar. Okay. That concludes our calendar for the day. A motion? We are adjourned.